and thank you for attending today's SAVAT session on sexual assault response teams. My name is Summer Gaines Wheeler. I am MCASA's Sexual Assault Forensic Exam and Sexual Assault Response Team Policy Advocate. As Alyssa already mentioned, you'll be hearing from 3 presentations today and learning about how your role as a victim advocate intersects with the role of forensic nurses, law enforcement officers, and prosecutors. Today, I will be presenting on the role of the forensic nurse examiner, also known as a FNE. If you have any questions that come about during this portion of the presentation, please feel free to drop them in the chat, and I or another staff member will try to answer them. So to get things started, I wanted to just quickly introduce some of our SMART objectives for all of the sessions that you guys will be having for today. By the end of this SAVAT training, advocates should be able to, 1, compare and contrast their role with the role of law enforcement, forensic nurses, and prosecutors. 2, describe what a sexual assault forensic exam is. 3, explain the importance of advocacy throughout the criminal justice process. 4, identify the 3 responsibilities of law enforcement officers. And 5, understand the relationship between prosecutors and victims to better manage victim expectations throughout the criminal justice process. So before we move forward with the actual content for today's training, I would love for you guys to drop in the chat whether you guys have ever accompanied a survivor during a sexual assault forensic exam as a victim advocate. Unfortunately, I don't know if I'll be able to see the chat given how I'm presenting, but please feel free to share whether this has been something that you've participated in. We would love to see the different levels of experience before getting into the content. So I'll give you guys a few seconds.
You have a pretty good mix of people that have attended forensic exams and have not.
Awesome. Okay, awesome. Well, thank you guys for sharing. We're going to move forward with the actual content for today's FNE training. So to start out, I want to discuss what a SAFE is. A SAFE stands for Sexual Assault Forensic Exam, and it is a procedure that provides survivors with important medical care, and it also allows for the collection and preservation of potential evidence from an assault. So a helpful way to understand a SAFE is to separate it into 2 parts. So you have your medical attention, and then you also have evidence collection. The medical attention portion includes elements such as checking and treating for potential injuries, providing any STI prevention, treatment, and or testing, as well as offering pregnancy prevention. So for example, offering emergency contraception pills like Plan B. The evidence collection portion includes taking photos of injuries, collecting DNA, as well as collecting clothing items. It's important to note that in the state of Maryland, SAFEs conducted up to 15 days after the assault occurred will be reimbursed. The new law also does not specifically state that only cervical swabs should be collected when a victim presents more than 5 days after an assault. So when understanding the process of receiving a sexual assault forensic exam and reporting sexual assaults, there are different options available to survivors. Survivors have the ability to either report a sexual assault either to the emergency department, law enforcement, and or to a rape crisis center advocate. It is possible that survivors reporting to the emergency department may choose not to receive the sexual assault forensic exam and instead just receive medical treatment. If they choose not to receive a SAFE, advocate presence should still be offered. Additionally, Child Protective Services and Adult Protective Services are called into cases that involve child sex abuse or cases that involve vulnerable adults. According to the Maryland's Office of the Attorney General, vulnerable adults are people over the age of 18 who lack the physical or mental capacity to provide for their daily needs. So now moving into advocacy and really how this applies to your guys' work, right? Advocates are available to survivors before, during, and after any portion of the sexual assault forensic exam, including in the exam room. Before an exam, advocates can work to address acute concerns identified by the survivor, work through any questions about the exam process, explain their role in services, and review potential reporting options. During the exam, advocates can help support the survivor through any or all parts of the exam, including offering grounding strategies, co-regulating, offering encouragement, as well as empowering the survivor to choose from the different exam options. So, I also want to note, please be aware of what to do if you are invited into the exam room. For example, please do not speak for the survivor, do not touch any of the nurse's tools. Overall, it's really important to understand your physical place and space in the room itself. Also, be prepared to ask the survivor if they would like privacy or for you to stay during various parts of the exam. For example, you may encounter some survivors who would prefer your physical presence during the narrative portion of the exam, but may request privacy during a speculum exam and or during any part of the evidence collection. After the exam, advocates can work on a safety plan for the post-crisis intervention period, as well as connect survivors with ongoing community and advocacy referrals and address ongoing concerns. The safe hospital should also have a protocol in place in which an advocate is immediately notified when a survivor presents to the emergency department. Advocates can then work with forensic nurse examiners and potentially law enforcement to ensure a timely survivor-centered, coordinated response to the hospital. I also want to note that a survivor may choose to have an advocate at the hospital, even if they choose not to have a safe completed. Likewise, as mentioned, survivors are not required to have an advocate present and may choose not to. In this situation, an advocate can provide contact information or any other relevant community referrals for the survivor to reach out to if they want to in the future. Overall, I think what we want to ensure is that the survivor is having their autonomy and the ability to make a decision for what feels right to them. So now I want to talk a little bit about what actually occurs during a sexual assault forensic exam. So I know it's my last bullet point, but I want to note that an exam can last anywhere between 3 to 6 hours, and it includes several important elements, including a detailed interview by a F&E, a body exam, evidence collection, photographs, and documentation of findings. Please note that a survivor can choose not to receive any portion of the exam at any time. During the interview, survivors can disclose what they choose to about the assault. However, an advocate can also gently encourage details as it will impact medical prescriptions and evidence collection. So during the external body exam, the forensic nurse will look for bruising, wounds, and other injuries that may have occurred during the assault. If any injuries are present, the forensic nurse examiner will then use photos to document the wounded areas. And you can see some examples of this on the screen towards the right. There are also cases where injuries are not so visible, right? So, for example, in strangulation cases, in these instances, an alternate light source may be used to photograph the areas. And basically, an alternate light source is a technique that can detect bruising or injury that has occurred beneath the skin layer and is not available to the naked eye. So, a forensic nurse will also use cotton swabs to collect evidence from various parts of the body, including the skin, inside the mouth, and under the fingernails. A genital and anal exam are also completed, in which a forensic nurse conducts both internal and external swabs of the area. The areas that are swabbed are based on the victim's narrative of the assault provided to the forensic nurse. So, this is also why providing details may be especially important, as it can guide evidence collection and increase the likelihood of obtaining DNA. However, I do want to reemphasize that as an advocate, one should never speak for the survivor or force them to provide more details than they are willing. However, supporting them during this process and helping explain why it is important and valuable to provide details may be beneficial. So now I want to talk about what occurs after an exam. It's important to mention that safes are free of cost with or without insurance, as they are government funded. The forensic nurse or advocate will inform the survivor about community resources available to them, including counseling or support groups. The survivor will also be offered, as mentioned before, emergency contraceptives, STI prophylaxis, and HIV prophylaxis free of cost. The exam is free, regardless of a survivor's decision to report to law enforcement. I do want to note that currently, the Sexual Assault Reimbursement Unit, also known as SARU, is evaluating if medical only exams are covered by the state. But it is our current understanding that only sexual assault forensic exams are reimbursed, as it involves evidence collection. So, I want to quickly discuss evidence preservation. So, there are several things that a survivor can do to best preserve evidence before getting a safe. For example, not changing clothes is important because the survivor's clothes will be collected into evidence during the safe. However, if the survivor does change clothes, they should still bring the clothes with them to the hospital. It is also advised to refrain from using the bathroom, eating, drinking, or brushing teeth. Additionally, refraining from a shower or bath beforehand is also advised in terms of evidence preservation. I do want to emphasize that if a survivor has done any or all of the previous listed activities, please do not discourage them from getting a sexual assault forensic exam. The forensic nurse examiner will still attempt to collect evidence. So, the last thing that I want to show you guys is a video that discusses the importance of advocacy during a safe. I do want to just give a brief content warning. Obviously, the nature of this can be a bit sensitive, but I do find this to be a pretty effective video. So, I'm going to give this a play. Hopefully, it works. We were having some trouble before.
Rape is a reality across the globe, including right here in Chicago. For survivors, support is crucial on their road to recovery.
I'm an 11-month survivor of rape.
According to the CDC, 1 out of 5 Illinois residents have reported a rape. One local organization seeks to help victims of sexual abuse by providing immediate, round-the-clock support in 14 area hospitals.
Essentially, if a victim of sexual violence shows up at any of those hospitals, the hospital pages us, we dispatch an advocate, it doesn't matter what time it is, and that advocate is there really solely for the victim.
During a traumatic time like this, you are not able to think or understand what people are saying. So it helps to have someone there to be supportive, to actually advocate for you and help you navigate through the system, and to provide you with all of the services that you're entitled to based on the law and based on what your needs are.
The survivor we spoke with was raped while on a date, and unfortunately, she is not alone. 2 out of 3 reported rapes are committed by someone the survivor knows. Sharmili says it's crucial to let survivors know you support and believe them early on in the process.
When I was in the emergency room, I was asked if I wanted an advocate, and I said yes. So my advocate, Providenza, showed up within an hour. It was just so reassuring to have somebody who believed me and was on my side.
There's actually been research done that shows that having immediate care right after someone is assaulted and in an emergency room setting actually improves the ability of the person on their road to recovery in terms of their emotional healing, but also in terms of their case being taken as seriously as possible.
If I had not had an advocate, I would not have been aware of the civil no contact order that I was able to get temporarily. I would not have known about Illinois law that funds the ER visit and the follow-up care. I wouldn't have pursued probably therapy on my own to help heal, and that was such an important piece of healing.
When it comes to making societal changes, seemingly small steps can make a big impact.
Most likely, there are people in your life who are survivors of sexual violence that you don't even know about. There are people that you hang out with, there are people that you go to school with, there are people that you work with. Part of what we're hoping is that people will talk a little bit more about the issue of sexual violence, because all of us are bystanders in some way, and so we have the ability to interrupt behavior, language that supports sexual violence. Rape jokes are not funny, for example, and things like that actually create an environment in which victims don't feel like they can come forward, and the people who perpetrate feel like they kind of have license to do what it is that they do.
The survivor we spoke with has a message of her own, one that is clear and simple.
No is no. Anything other than yes, let's do this is no. No matter what age or how I'm dressed or what time of night it is or how much I had to drink. I am a human and I deserve to be treated with respect.
Sexual assault is a traumatic event, but there is hope.
I am so much stronger than I think I am because I survived this. And not only did I survive, I'm thriving. I grew through this process. It was painful and it hurt so bad. And there were some really low lows, but I survived. If one person who sees this segment can benefit and seek the help that they need to heal from this, then my assault won't be in vain.
If you or someone you know is a victim of sexual assault, please contact the 24-hour Chicago Rape Crisis Hotline at 888-293-2080. For more information, head to our website, livinghealthytv.com.
All right, so that concludes the end of this presentation. I really hope that not only this video, but this overall training, whether you've accompanied survivors to a safe or not, gave you a little bit more insight about how you guys as victim advocates play such a huge role in supporting survivors as well as forensic nurse examiners. I do also want to note that at the very end of all of the SART trainings for today, we will have a recorded sexual assault response team panel that includes various professionals that we are discussing today, right? The prosecutor, the forensic nurse examiner, law enforcement, victim advocates. They're all participating in a panel where they discuss kind of their work and SART as a whole. And that video will be uploaded on our MCASA YouTube channel soon. And we would really like for you guys to all watch that after today's session to complete the training. This is my contact information for anyone who wants to reach out. But I really appreciate you guys taking the time to listen to today's training. And I will hand it over to Cameron.
Okay, can we all see my screen?
Yes.
Perfect. Okay. So, hello everyone. I am Cameron, and I am the Sexual Assault Response Team and Sexual Assault Kit Initiative Policy Advocate with MCASA. Today, I'm going to be talking about the role of law enforcement and how they collaborate with you all as victim advocates to serve and support survivors. Full disclosure, I have never worked for a law enforcement agency and I do not claim to have, but this is just a high-level overview of how law enforcement engages with survivors and victim advocates. So first, I want to talk about sexual assault reporting methods. There are several ways that law enforcement may receive these reports. The first is through hospital personnel. So this is going to occur when a survivor reports directly to a hospital for a sexual assault forensic exam, and they do this before they contact law enforcement. And from here, they are then given the option to report to law enforcement. But it's important to note that they are not obligated to, and this will not impact their right to a sexual assault forensic exam. If a survivor would like to involve law enforcement, they will have the hospital personnel contact the local agency, and then the agency will come to the hospital and eventually interview. Survivors also have the option of reporting to law enforcement themselves directly, and this can happen while the assault is in progress, directly after the assault, or they have the option of a delayed report. So a delayed report can happen anywhere from a few days to even years after the incident, but regardless, law enforcement will still take that report and investigate. Law enforcement can also receive reports from a third party or witness, but it's really important to note that if they receive a report this way, they're limited in their scope of what they can do. They can't force a survivor to engage in the criminal process if they do not want to, unless it's under certain circumstances like a child or vulnerable adults or cases like that. So next, I'm going to be talking about the responsibilities of law enforcement. So the initial interaction between law enforcement and survivors is extremely important because it's laying the foundation for future interactions with survivors. So this is a really good opportunity for law enforcement to build rapport and trust with the survivor, let survivors know the next steps, and let them determine how they would like to move forward. Summer mentioned this in her forensic nurse presentation. It's really all about encouraging the autonomy of the survivor. So during these interactions, it's really important to remember to use techniques like the forensic experiential trauma interview, which also is called FETI, and that focuses on compassionate interviewing, building rapport, and being empathetic to support the survivor and encourage participation in the criminal justice system. Another important responsibility of the law enforcement is assessing the need for safety and medical care. So if a survivor reports to law enforcement prior to receiving forensic medical care, it is important that law enforcement assesses the need for emergency medical care and informs survivors of the safe process and how it may aid in a criminal investigation. Any survivor that is interested in receiving a sexual assault forensic exam should have the opportunity to do so, and this includes survivors who submit delayed reports. Survivors should have the opportunity to see a healthcare provider even if evidence is not being collected, and law enforcement is not able to deny a survivor access to a sexual assault forensic exam. As a victim advocate, you are there to help ensure that forensic medical care is accessible, and it's also important to remember that these exams are available for 15 days post-assault, but the earlier the better, and this can aid in the criminal justice process. Their next priority after addressing safety, medical care, and physical and mental well-being is going to be to collect information on the suspect. Not only is this helpful for the investigation, but it is also crucial for both the survivor and public safety. Law enforcement typically initially seeks the basic information on where the assault occurred, and then from here, they are able to secure the scene and begin examining the area for any additional evidence. It's also important to note that law enforcement may ask a survivor if they've told anyone, so a friend or a family, and this is not because they doubt it, and they also, it's they often ask this during delayed reports. It is because it can corroborate the survivor's story. So advocates can support survivors by explaining that law enforcement doesn't doubt them. They're just looking for supporting evidence that could be essential in the investigation. So law enforcement responsibilities lies in 3 areas. The first is protecting and supporting the victim. The second is gathering preliminary information. And the third is protecting the crime scene to collect evidence related to the case. It's really important that when law enforcement is doing this work, they are being trauma informed, and part of that includes involving victim advocates. Most law enforcement agencies work with their local rape crisis centers, and they can provide support beyond just the initial investigation. Law enforcement and advocates can work together to complete other things like safety planning for the family, addressing childcare, finding housing, and other important things like that that survivors may not think about. So law enforcement can and should use the Rape Crisis Center to connect survivors to this type of support. Law enforcement should also be aware that survivors may experience symptoms of trauma that affect their ability to recall information, and survivors experience a range of emotion. This can include hyperactivity, depression, flat affect, shock, a variety of things. It's important that all parties recognize that there is no correct emotion for survivors to display after an assault. Some of you may have had the opportunity to sit in on our neurobiology of trauma presentation yesterday. That does a really good job covering all the bases. And all investigators should be trained on trauma-informed interviewing techniques, and they should understand the neurobiology of trauma so that they are able to support the victim and conduct a successful interview. So now I'm going to talk more about the actual investigation. Law enforcement, as you all know, is responsible for conducting a thorough criminal investigation, but it's also really important that they ensure the safety of the survivor and their support group, whether it be friends or family. And addressing safety can ensure that the survivor feels comfortable enough to participate in the criminal justice system. As an advocate, safety is also something that you should be sure to evaluate and address through proper safety planning. Once the survivor's safety is addressed, law enforcement is able to move on with other steps of the investigation. They should determine whether or not the victim knew the suspect or had any previous contact. Despite the belief that rapes are perpetrated by strangers, statistics show that approximately 75% of rapes are committed by someone known to the individual. This is important to distinguish because knowing if the offender is a known individual or stranger can be essential in determining the next steps of the investigation. Stranger rape cases may require the survivor to participate in a more detailed interview immediately after because there could be a threat to the community. But if the offender is known, law enforcement is able to narrow it down more and obtain basic information that will allow the investigation to continue while giving the victim time and space to process what has happened before they participate in a more detailed interview process. Other things that law enforcement may want to obtain immediately may include, do you know where the suspect is now? How did the suspect leave the scene? Do you know where the suspect is going? They also might want to know if there was a weapon used or if there was drugs used, threats, force, because all of these also pose a safety risk. And with all of these details, law enforcement is able to determine the ability to get a search and seizure warrant. Another part of the investigation is the forensic analysis of the sexual assault evidence kit, which you heard a little bit about in Summer's presentation. This includes looking at the photographs, testing the DNA samples, and more to help with the investigation. As a victim advocate, you are able to be present for some of these questions. Some of these questions, like what were you wearing, may sound or come across as victim blaming. So it's important that you are there to translate for survivors and provide background context so that they understand why these questions are being asked to help avoid re-traumatization and develop understanding on the survivor's part. So next I'm going to talk about evidence, which is what Summer just touched on with the sexual assault forensic exams. There are multiple types of evidence that law enforcement looks into for their investigation. but the main one is the Sexual Assault Evidence Kit, or SAKE. Survivors have the right to a free sexual assault forensic exam up to 15 days after an assault, and it is at these exams where the SAKE is collected. And this SAKE is then stored with the law enforcement agency along with other evidence from the crime scene. And these are all things they look into with regard to physical evidence. And it's really important to note that these kits have to be held for a minimum of 75 years. Some of this evidence, like clothing or bodily fluids, is also going to be collected during the sexual assault forensic exam from the nurse. And after the collection, the law enforcement's responsibility is to then go to the hospital and obtain the kit from the SAFE program and store it in their law enforcement agency as evidence. It is their responsibility to safeguard items of evidentiary value in accordance with Maryland law and best practices. Other forms of evidence can include things like cell phone communication, social media. So law enforcement is able to obtain warrants to go through phones. And this is not the end-all be-all list, especially as technology advances. I'm sure there are going to be more forms of evidence that pop up. And also, it's really important to note that details provided by the survivor or the offender or even the witnesses can lead to the additional collection of evidence. So if a survivor says they were at a party, law enforcement may be able to collect cups that were at the party and search for DNA that way. Or if the survivor says they were at the bar, law enforcement can go to the bar and obtain security footage. So next, I'm going to talk about the importance of anonymous reporting. Survivors do not have to report to law enforcement. They have the right to an anonymous exam, and this means that there will be no official police report until the survivor chooses to initiate one. The anonymous kit is sorted with the law enforcement agency and stored, but there's no identifiable information on the kit. It is tracked with a number, and just like the other kits, it will be held for 75 years. And during those 75 years, a survivor can come forward at any point and initiate the investigation. And when that happens, law enforcement will open the kit and gather details. And until then, it is simply stored with no identifiable information. This option is really important because it allows victims to preserve evidence and receive medical care without having to speak with law enforcement. And it also allows survivors the time to process and recover from the assault prior to reporting. Then they are able to move forward if/when they are comfortable, and they are able to do everything at their own discretion, which again is something we want to encourage. As an advocate, it's important to discuss how anonymous reporting can affect the criminal investigation. You want to make the survivor know that they don't have to report the assault immediately, but you may want to inform them that evidence collected from the scene or from the offender may be lost if they choose not to report immediately, but this is the survivor's decision. So do not try to incorporate your personal opinion or make them lean a certain way. Just encourage them to do whatever is best for them. So I want to take a moment just to pause and ask you all to participate in the chat. How can advocates support survivors while working alongside law enforcement? So you can either speak from personal experience or something you want to do moving forward. How would you support them during this process? Keep them up to date on what's happening with their case. Definitely.
Are we able to speak?
Yeah, go for it.
Okay. I would provide as much support as I can, try to be there, let them know that, what, I'm here with you, just in case you might feel like, you need someone physical presence there.
Yes, very good. Be supportive and non-judgmental. Help to understand questions, explain their options. Mediating to ensure information is communicated in a sensitive manner. If they haven't been offered water or food, make sure to offer that, make sure they're comfortable. Not answering for them. These are all really good. Awesome. So I'm going to talk a little bit now about the role of an advocate. Your role as an advocate during an investigation is all about the survivor. If you are involved in the interviewing process, you want to ask what their needs are and you want to inform them of their rights, like a crime victims' rights attorney, their rights when it comes to kits and reporting, and making relevant referrals. Advocates often provide support and accompaniment to victims during an exam or interview, and they also check in with victims' emotional state, provide reassurance or validation, and also advocate for breaks if needed. Be mindful, though, when you are asking if the survivor would like a snack, drink, or a bathroom break, because a survivor should not eat or drink anything if they are still waiting for a forensic exam. Additionally, survivors should try to refrain from using the bathroom before the forensic exam. But if they do need to use the restroom, try to inform a nurse so that a urine sample can be collected. As an advocate, if you aren't sure about something, ask the forensic nurse available. Advocating for bathroom breaks, snacks, and drinks is much different during an interview with law enforcement or if an exam has already been completed. And it's also important to note that it's okay to be silent. Sometimes a victim may just want you to be present, which one of our participants mentioned, so you don't have to speak for them. You, as an advocate, can also assist victims in asserting their rights. While we encourage victims to come forward, we need to remember that under the Violence Against Women Act, no victim is required to speak with law enforcement or participate in the criminal justice process. It's also important to provide comfort especially during the law enforcement interview. It is appropriate to remind victims that they can take a break or ask questions whenever they need. Keep in mind that although it is best practice for law enforcement to allow an advocate to be present during victim interviews, your local jurisdiction may not permit it. If that's the case, you can provide information on best practices and agree to not interrupt the survivor or guide their story in response. If you are still not permitted, you can remain outside the interview room and be available to provide support when needed. I'm going to go over some advocate basics. You want to advocate for their desires, provide emotional support, assist in safety planning, and assist with other referrals. It's not always going to be about the investigation for the survivor. It is going to be about healing and supporting them. A 2006 study found that survivors who had the assistance of an advocate were significantly more likely to have police reports taken and were less likely to be treated negatively by police officers. They also reported less distress after their contact with the legal system. While advocates certainly strive to protect relationships with other professionals, their role requires them to work on behalf of each victim's stated wishes. I want to talk about things you want to avoid as an advocate because it can kind of be hard to separate your personal feelings and opinions. And you may have strong feelings about a victim reporting or not, but it is essential to keep any opinions out of the conversation because you can directly impact a victim's decision, and that is the last thing we want to do. Survivors may ask for advice, or they may ask if you personally are a survivor and what you did when you were in their shoes. But it's important not to share your personal decisions or self-disclose because it is about their needs. There's no right or wrong or perfect way of doing this. If a victim asks what you would do in the situation, or if you have been assaulted and if you reported, it's important to know how to answer this question in a manner that highlights the victim's unique circumstances, needs, and goals. If asked something like this, you can try to respond with something like, I think it's really important that we focus on your current circumstances. Every individual is different, and although it may seem like it will be helpful to hear what other people have or would do, you need to make sure you make the best decision for you. You really want to encourage their autonomy and their choice. It's also important that you do not interview the victim. It is not part of your role to ask substantive questions or to provide information about the sexual assault. If you find the victim is having trouble understanding questions during the interview, it may be appropriate for you to provide a prompt for the victim by asking law enforcement for further clarity on the question. So this type of prompt should be neutral and with the sole purpose of obtaining clarity, like would you like the nurse or officer to explain this again? You don't want to directly ask the question yourself. You also want to be honest with each survivor. Promises can lead to false hope, and if they do not pan out, like the suspect doesn't end up being arrested or convicted, the pain and disappointment can result in survivors refraining from engaging in further support services. It's much better to be empathetic and say things like, I am so sorry you're going through this. I believe you. I believe this happened to you, than to make any promises. Keep in mind that not all survivors have the same view of justice, and that view of justice can change over time. So you want to allow each survivor to define the justice they seek, even if that just means time to heal and recognition that they experienced something traumatic. And you want to support them in their attempts to achieve that. So just really take a step back and remember that not all of these survivors are going to want to go through the criminal justice process. They may just want to have the acknowledgement of the event. To summarize really quickly, you want to recognize that not all survivors will respond to an assault the same. Their emotions and demeanors may vary from person to person. Remember that not all survivors want to report to law enforcement, so it is important that you provide information to each survivor to ensure they make an informed decision, but do not provide your personal opinion. You want to focus on the survivor's needs, especially safety. Safety should always be the utmost priority. You want to support the survivor during the investigative process. If you're permitted to sit in on interviews with law enforcement, be sure to advocate for the survivor's needs and prompt investigators to provide clarity if the survivor is struggling with a particular question. Do not speak for the survivor, because this can both affect an investigation and potential prosecution or conviction, and it takes autonomy away from the survivor. You also need to know your agency's services and other local resources so that you are able to make the important referrals for the victim. You also should know your confidentiality requirements and protect each survivor's personally identifiable information and care plans. Even if a survivor is participating in the criminal justice system, remember what your confidentiality requirements are. You want to keep the information of the survivor private and secure. Law enforcement may want information provided to you, but without survivor consent, you must maintain confidentiality as required by your discipline and funding avenues like the Violence Against Women Act. Thank you all for sitting in on my portion of the presentation. This is my contact information, and I'm going to pass it over to Lindsay to talk about the role of the prosecutor.
Thanks, Cameron. Hi, everyone. Just bear with me while I get situated here. Alyssa, can you just confirm that you can see my presentation?
Yep, I can see it.
Wonderful, thank you.
Yep.
And then at any point, if the audience can't hear me, Alyssa, if you're able to come off of mute and just let me know in case I miss it in the chat, I would greatly appreciate that.
Yep, no problem.
Okay, awesome. All right, so good morning, everyone. My name is Lindsay O'Neill, and I am a senior staff attorney at MCASA's Sexual Assault Legal Institute, also known as SALI. I am also the Sexual Assault Kit Initiative project attorney at SALI, and in that role, I provide legal services to survivors impacted by the backlog in untested and unsubmitted sexual assault evidence kits in Maryland, as well as training and technical assistance on sexual assault evidence kits and crime victims' rights to other professionals who are working with survivors in Maryland. As Cameron mentioned, today I am presenting on the role of the prosecutor in the sexual assault response team. Just as a note, throughout my presentation today, I will be using the terms victim and survivor interchangeably. Just please keep in mind that victim is a legal term that evokes certain rights under the criminal code, which is why I will be using it today. So I'd like to start things off with a few poll questions. For some of you, the answers to these poll questions are going to be no-brainers. For those of you who may be newer to this work, you may not know the answer, and that's perfectly okay. Just give it your best shot. So I'm going to give everyone a moment to provide a response, and then we'll talk about the answers. Okay, so I'm going to go ahead and end the poll in a second. Record your response. Okay. Can everyone see the poll results? We have 39% said the victim and the state, 33% said the state, 22% said
fell
the
asleep
victim.
until like 4 or 5 in the morning, and I had to be up at 6.
And then 6% said the defendant. So the correct answer here is D. Prosecutors represent the state in a criminal case. They do not represent the individual victim. At the federal level, they represent the whole country. Victims, especially when it's their first time engaging in the criminal justice system, often think that the prosecutor is their attorney, which is an understandable misconception. Unfortunately, that can be somewhat problematic for reasons that we're going to discuss in a moment. But as advocates, you can help victims understand the prosecutor's role and the victim's role in the criminal justice system to help set those expectations and also ensure that our victims have the correct information to make informed decisions throughout the criminal justice process. So let's move on to our second poll question, which is, what are prosecutors called in Maryland? Are they prosecutors? Are they state's attorneys or assistant state's attorneys? District attorneys or assistant district attorneys? County attorneys or assistant county attorneys? I'll give you all a moment to respond. Okay, I'm going to give everyone another second. I would just like to note that I think somebody is off of mute. I can hear some background noise. So if you haven't muted yourself, if you could go ahead and do that now. All right, so I'm going to end the poll. I'm sharing the results. So great job, everyone. The majority of you said state's attorneys or assistant state's attorneys. The answer is state's attorneys. So in Maryland, elected prosecutors for each county in Baltimore City are called state's attorneys, and then the prosecutors who work under the state's attorneys are called assistant state's attorneys. Okay, final poll question before we move on to some more content. Who decides if criminal charges are filed? Is it A, the prosecutor? Is it the police, the victim, or the defendant? Okay, I'm going to go ahead and end the poll. Once again, great job, everyone. The answer is A. The prosecutor gets to decide if charges are filed, and if so, what charges are filed and against who. As advocates, you'll often hear victims say, I want to press charges. I think we have the media to blame for that phrase because there really is no such thing as a victim pressing charges. A victim can report a crime either to the police or the state's attorney's office, or the commissioner's office, but it's up to the state's attorney to ultimately decide whether or not to prosecute. Okay, so that is it for our polls. Thank you all so much for participating. So as we just learned from our poll question, prosecutors are attorneys who represent the whole state or country, not the individual victim. And this is important because since prosecutors do not represent survivors, there's no confidentiality between the prosecutor and the survivor, and there's no attorney-client privilege. In fact, prosecutors actually have ethical obligations under the United States Constitution and state law that require them to turn certain information over to defense and to the courts. That can include information shared by the victim. An example of this would be a victim's request for a U visa certification. U visas are for non-citizen victims of serious crimes in the United States. If a victim asks the police or the state's attorney's office to sign a form stating that they were helpful or cooperative so that they can get their U visa, the state's attorney's office will have to share that information with defense, and that could jeopardize the outcome of the criminal case. Additionally, since prosecutors represent the state or the country and not the individual survivor, their interests may at times conflict with the survivor's interests. For example, prosecutors want to secure convictions, and in doing that, they may offer a plea deal to a defendant when the victim prefers to go forward with a trial on all charges so that they can have their day in court. In Maryland, prosecutors' offices are called state's attorney's offices. They may be called something different in other states like district attorneys, which I'm sure many of you have heard that phrase, and then federally, United States attorneys. There is one state's attorney in every Maryland jurisdiction. That person is elected. The lawyers who go to court on behalf of the state are called the assistant state's attorneys, which I mentioned earlier. Prosecutors run the criminal cases for the state. They decide if someone gets charged, what crimes are charged, whether to offer a plea bargain or go to trial, and what plea bargain to offer if there is one, what evidence should be put on at trial, and what sentence they will argue for after a conviction. It's up to the state's attorney to decide who gets charged with the crime because they have something called prosecutorial discretion. A famous quote from the United States Supreme Court case reads, "So long as the prosecutor has probable cause to believe that the accused committed an offense defined by statute, the decision whether or not to prosecute and what charge to file or bring before a grand jury generally rests entirely in the prosecutor's discretion." Once a decision on whether or not to prosecute has been made, it's generally final and it can be difficult to change. However, in my experience, prosecutors will usually consider a victim's wishes in their decision. And fortunately, under Maryland law, in sexual assault cases, the victim has the right to a meeting with the state's attorney on that decision to dismiss charges or a decision not to charge a suspect. As advocates, you can help survivors understand why a case may not have been charged or why it may have been dismissed. A survivor may think that a prosecutor did not believe them, but that's typically not the case. Oftentimes, a state's attorney's office will decline to charge because they don't think there's enough evidence to prove their case beyond a reasonable doubt, which is their burden of proof in criminal court, and it's the highest burden of proof in court. This is especially true in sexual assault cases where, due to the nature of the crime, there may be little evidence or few to no witnesses. So how do prosecutors determine what crime to charge, if any? They need to look at the facts of the case or the conduct alleged to determine what crime or crimes occurred, if any. They, of course, are going to evaluate any evidence, which I mentioned earlier can be difficult in sexual assault cases because the nature of the crime, you typically have no witnesses, and the evidence may often just be a survivor's word against the perpetrators. Prosecutors also have to consider, by law, whether there is probable cause to charge. In other words, whether there is sufficient reason to believe the crime occurred and the person charged is the person who committed it. Prosecutors don't have to believe that there is sufficient evidence to prove a case beyond a reasonable doubt in order to be able to charge a case, but most prosecutors will in fact consider that in their decision because it is the burden of proof if that case goes to trial. And they certainly don't want to put a survivor through the criminal justice process if they think there's going to be a high probability that they will lose the trial. Prosecutors can also take into consideration various objectives in deciding whether or not to charge someone with a crime. For example, they can consider the seriousness of the offense. They can also consider the defendant's background and criminal history. Perhaps that defendant is a repeat offender. They can take those things into consideration. So I just alluded to this difference between probable cause and beyond a reasonable doubt. Probable cause is sufficient reason to believe that based upon known facts, the crime has been committed or that certain property is connected with a crime. This will also include probable cause to believe that the particular person who's being charged is in fact the person who committed the crime. Many times, the survivor will know the identity of the perpetrator, and identity is not going to be an issue, but it could be a problem in some cases, such as stranger rape cases, for example. Probable cause is required to charge someone with a crime. If the case goes to trial, as part of the jury instructions, the jurors are told that they can only find the defendant guilty if they are convinced beyond a reasonable doubt of his or her guilt. Beyond a reasonable doubt, it doesn't require absolute certainty of guilt, but it does require that there are no other reasonable explanations other than the defendant being guilty. The burden of proof, at trial is beyond a reasonable doubt, and that's even the case if the judge is the fact finder, which is known as a bench trial rather than a jury trial. So I'd like to take a moment to dig a little bit deeper into how prosecutors decide what crime to charge, if any, and then we'll look at an example. So prosecutors need to look at whether the conduct alleged satisfy all of the elements of a particular crime or crimes. The elements of the crime are the parts of the crime that must each be proven beyond a reasonable doubt in order to sustain a conviction. Not all bad behavior is a crime under Maryland law, even if we think it should be. So for example, stealthing, which is when a person lies about putting a condom on during sexual intercourse or removes a condom during sexual intercourse without the other person's permission, that is not a crime in and of itself in Maryland. It's a crime in other states, but it is not a crime here. Additionally, one act may lead to multiple charges. So for example, anything that can be charged as rape can also be charged as sex offense in the 4th degree, which is an unwanted sexual touching. And then it can be charged as assault in the 2nd degree, which is an unwanted offensive touching. Prosecutors will also take into consideration whether the alleged conduct makes out a felony or a misdemeanor crime. Felonies are higher level crimes, whereas misdemeanors are lower level crimes. In Maryland, many misdemeanors have statutes of limitations with some exceptions. For example, revenge porn is a misdemeanor crime in Maryland. However, due to fairly recent law, there is no criminal statute of limitations for prosecuting revenge porn. Felonies, on the other hand, do not have a statute of limitations. They can be brought against a perpetrator at any time, sometimes even decades later. Most misdemeanors, on the other hand, do have to be charged shortly after the crime occurs. Otherwise, they cannot be charged later. For example, sex offense in the 4th degree is a misdemeanor crime, and it must be reported within a year of the incident. Okay, so I said we were going to look at an example. I would like to know from all of you what your definition of harassment is, or what is it that you think of when you hear harassment or that somebody is being harassed. If you could go ahead and just take some time to type your responses in the chat, I would greatly appreciate it. We have one response so far. Thank you so much. Unwanted contact from another person. We have another unwanted contact, unwanted behavior, unwanted calls, visits, threats. Those are some good examples. A persistent and malicious act, an unsolicited message, a constant text from an unwanted person, stalking. These are all really great responses, and I appreciate, again, your participation. Being approached aggressively, unwelcome contact that causes mental or emotional distress. Excellent. Okay, so let's look at Maryland's definition of harassment. This is our legal definition, so I've included an excerpt from the criminal code. So in Maryland, harassment is actually defined as following another individual in or around a public place or maliciously engaging in repeated behavior that seriously annoys or alarms another individual with the intent to annoy, alarm, or harass after being reasonably requested or warned to stop the behavior by the individual or someone acting on behalf of the individual without any legal purposes. Just as a side note, come October 1st, 2025, this law is actually now going to include intentional visual surveillance of a person's residence. So, for example, their yards, where that person has a reasonable expectation of privacy. So as you can probably tell, that our legal definition of harassment under Maryland law differs quite a bit from our normative understanding of what would constitute this crime. What we often may think is a crime in a colloquial sense isn't going to always match the actual criminal law. When prosecutors are looking at whether or not they can charge harassment, for example, they have to consider some things that we probably wouldn't think of when we're just considering our normative understanding of what harassment is. So, for example, they have to determine if there was a legal purpose for the conduct. Let's take a case where the victim and the perpetrator have children in common. The perpetrator might argue that the 92 phone calls and 200 emails were about the children. And unfortunately, depending on what type of custody or protective order might be in place, that could prevent a prosecutor from moving forward, or they may not wish to move forward because that could be a potential issue. Another important question that they have to consider that we might not think of is, did the perpetrator keep doing it after they were told to stop? Or did the victim tell the perpetrator to stop at all? They can't charge harassment if there wasn't a request to stop, or if the defendant did not continue after they were asked to stop. I think this goes back to managing survivor expectations, which I think is really important throughout the criminal justice process. Just because a particular crime can't be charged, it doesn't mean that the prosecutor's office thinks that what happened was okay, or that they don't believe the survivor. It may just mean that a very technical part of the law didn't occur. And I think harassment is an excellent example of that. Okay. So now we're going to move on to talk about evidence. I think it's quite obvious that in addition to examining the conduct alleged or the facts of the case, the prosecutors, they of course have to consider any evidence, right? They can consider admissible evidence, which is evidence that can come into a court case. They can also actually consider inadmissible evidence, because that evidence might ultimately lead to something that is in fact admissible. Let's take hearsay, for example. So let's say that Jane Doe testifies that Mary told her that John was at the party. In court, a judge or a jury would not be able to consider that testimony because it's hearsay, but a prosecutor, they can, because they can go talk to Mary directly and find out what she knows. Similarly, Rumors can't be brought up in court, but a prosecutor can investigate, and they can also talk to the people who are spreading those rumors. Some examples of admissible evidence that can be considered by prosecutors and the court would be photos, perhaps photos of injuries, for example, written statements. In order for that to come into court, there do need to be certain requirements that are met under the Maryland Rules of Evidence so that those statements themselves are not hearsay. But for example, if a defendant wrote a statement apologizing for what they did, that could potentially be admissible in court. We also have 911 calls, police testimony about what they observed and what actions they took, and any statements that were made to them by the defendant, medical records, other physical evidence, perhaps a piece of clothing, broken property, or there could be DNA evidence collected during a sexual assault forensic exam, electronic evidence, jail calls, mail. Electronic evidence would be like text messages, voicemails, locations, things of that nature. So we've talked about the burden of proof at trial. The reality is that most criminal cases never go to trial, and that's because the defendant accepts a plea bargain. And that's the same for civil cases. Most cases settle before trial. The defendant may be facing charges for the same conduct, so multiple charges for the same conduct. So they might be willing to plead guilty to the lesser of the offenses, or perhaps to the top charge, but lesser sentence. And that is all to avoid the risk of going to trial on all of the charges. Plea bargains can be a positive thing for some survivors. It really does depend on the individual survivor. The reason why it may be positive is because it means that the survivor doesn't have to testify at trial. As many of you can probably imagine, testifying can be incredibly invasive. It can be re-traumatizing, having to relive the events of the incident in front of a bunch of strangers. Plea bargains can also provide certainty about the outcome of the case, and they guarantee that the defendant will be convicted of something. On the other hand, if there is a plea bargain, then the victim doesn't get to have their day in court. The victim may also not agree with the plea offer, or they may feel that the plea offer doesn't account for what they experienced. So a huge example, this comes up a lot, is a plea to second-degree assault in a third-degree sex offense case, for example. Second-degree assault, it doesn't account for the sexual nature of the crime. It's just an offensive touching. It also doesn't require that if convicted, the defendant register for the sex offender registry. Another possibility short of trial is that charges are dropped. This is where the state would enter something called a nolle prosequi, or a null pros for short. That's when they're going to review the case more closely and determine that there just isn't enough evidence to prove the case beyond a reasonable doubt, or perhaps new exonerating evidence comes to light, which doesn't necessarily mean that the survivor lied. It just means that the state would have much more difficulty proving that the perpetrator committed the crime. It could also be that a key witness who is no longer available or cooperating, and that could be detrimental to the case moving forward. If charges are dropped, however, as I mentioned earlier, under Maryland law, prosecutors are required to explain why they are not bringing charges or why they drop charges if a sexual assault survivor requests it. So it's for sexual assault cases only. Now, if the case does go to trial, the trial will begin with voir dire, also known as jury selection, if it's going to be a jury trial. And then it's important to note too that the defendant is the one who gets to decide if they want a trial by a jury or by a judge. It's their constitutional right to make that determination. After that, the trial will proceed with opening statements by both parties. The state is going to go first because they have the burden. Their case can include direct and cross-examination of the victim witness and any other witnesses that may help to support the case. And then as a matter of course, defense attorneys will then make a motion for a judgment of acquittal after the state has rested their case and argue to the court that what was presented by prosecution was in some way legally insufficient. As advocates, you can make sure that the survivor knows that this is normal and to be expected. The defense can then also put on a case if they want to, but they're not required to do so. And the defendant does not have to testify, and their silence cannot be held against them. The defendant can still call other witnesses, even if they themselves do not wish to testify. After the defense's case, if any, the state can put on a rebuttal case. For example, if the defendant claims that they were out of state when the crime was committed, but the state has employment records that demonstrate that the defendant was in fact here when the crime was committed. And then following rebuttal cases, there is closing statements by both parties, then deliberations and a verdict. Jury instructions are given at the beginning and also at the end of the trial so that the jurors know what they need to be deliberating on and how they should render a verdict. Verdicts can happen quickly, or they can take a while. If jurors can't agree on a unanimous verdict of guilty or not guilty, it's a hung jury, and the judge can give an instruction to help the jurors reach a resolution. If not, the case results in a mistrial, and then the state will have the opportunity to try again, reach a plea bargain, or dismiss the case. In my experience, prosecutors will consult with the victim in making that decision on whether to retry or otherwise. If the defendant is in fact convicted, either by a plea or trial, the judge will decide and deliver a sentence at the sentencing hearing. In Maryland, there are sentencing guidelines that determine what the appropriate punishment should be based on certain characteristics about the defendant and about the crime. Despite that, judges in Maryland do have discretion to go above and beyond the guidelines, so long as they explain those reasons on the record. In my experience, judges will typically issue a sentence within guidelines. Each party will also have an opportunity to tell the court what they think the punishment will be. And victims themselves have a right to make a victim impact statement about how the crime has impacted their lives. The court shall take the victim impact statement into consideration when determining the punishment. Advocates can work with the victim to help them decide what to say to the judge and how to say it. They can also read the victim impact statement in court on behalf of the survivor if that's what the survivor wants. The only thing that you should remember is that the victim impact statement, it does need to be in the victim's own words. Please do not write the victim impact statement for the victim unless the victim is illiterate or has trouble writing. Then you can have conversations with them about what they would like to say, and you can document their thoughts that way. As a final note, I just want to touch upon prosecutor interactions with survivors. Those interactions may vary case by case. It can depend on the case, but it can also depend on the county. The interactions are either going to be done directly with the prosecutor, or it could be with the victim witness coordinator or the victim witness advocate who work at the state's attorney's office, and those individuals are usually social workers. The interactions can include an initial interview or perhaps like a screening interview when the prosecutor is deciding what to charge. The interactions can also include informing the survivor about the status of the case if the victim requests that. There's a specific form that they can fill out. They can also verbalize their request for information. And then any plea bargains. Prosecutors get to decide the plea bargains, as I mentioned earlier, but victims in Maryland have the right to be informed about the plea, and they can express their opinion on the plea. Interactions can also occur during preparation for trial, including preparation for direct and cross-examination. In my experience with felony cases, prosecutors will certainly meet with victims to prepare them prior to the trial. They usually try to prepare for trial closer to the date so that they don't have to bring the victim back in unnecessarily and make them relive their experience more than absolutely necessary. In misdemeanor cases in district court, whether or not there's preparation, it sort of depends. District court cases, they happen very fast. The prosecutors have a lot of cases that they have to get through. So, as a crime victims' rights attorney or as an advocate, you may have to help more with the preparation. And then I want to just re-highlight the fact that prosecutors are not confidential and there is no attorney-client privilege. As I mentioned earlier, they do have some obligations to tell information to defense and to the court, depending on what that information might be. That's why it can be so incredibly helpful for the victim to have a crime victims' rights attorney who can be a confidential and privileged resource throughout the criminal case and help that victim assert their rights, ensure that their rights are being respected, and also enforce their rights when there's been a violation. It can also be incredibly helpful for the victim to have a community-based advocate in addition to a system-based advocate, because that community-based advocate can provide some confidentiality. And if they're working with crime victims attorneys, then they can also have that privilege extend to them. Okay, so that concludes my presentation on the role of the prosecutor in the sexual assault response team. I just want to thank you all again for your time and attention this morning. I also want to thank you all for your participation. I really appreciate the participation. As a reminder, in case you don't know, Sally provides crime victims' rights representation in criminal cases as well as civil legal services. Our representation is dependent upon the capacity at the time of the request. If you ever have any questions, please do not hesitate to email me. I've placed my email here on the contact slide. It's LONEIll@mcasa.org. If you want to refer a survivor, please know that they can contact Sally directly to connect with one of our legal advocates for our intake process. And I have also listed that number on the slide, 301-565-2277.
Great. Thank you so much for that wonderful presentation, Lindsay. And thank you again to Summer and to Cameron for your presentations earlier this morning. I put the anonymous evaluation link into the chat. This evaluation is for all 3 presentations. So again, we greatly appreciate all feedback as we are constantly striving to improve. If you are seeking a certificate of attendance, you'll need to fill out the evaluation form to gain access to the certificate request form. You can expect an email later today with a copy of the PowerPoint slides used today, this video recording, the evaluation link, and also our sexual assault response team panel. So the presenters earlier this morning mentioned that we have a panel that they recorded with a law enforcement officer, prosecutor, forensic nurse, and victim advocate at a local rape crisis center. So feel free, if you'd like to get additional information on SARTs, you can watch that panel, and that will be in the follow-up email. So if you have any questions, feel free. We can stick around a little bit for questions. You can also email the presenters, and their contact information will be in the follow-up email. We hope to see you on Monday with our next presentation, and hope you have a great weekend.